till we'll just wait till the end of my presentation, and then I'll leave some time if folks have any questions. Happy to answer those for you. And I also want to mention that we're primarily going to be talking about estate planning in Maryland. It's a pretty state-specific legal topic, but folks may be living in DC. I can also talk about DC, Virginia as well, but primarily what I mentioned today is going to be Maryland focused. So for folks that pass away when they are living in Maryland. So let's get started. Do I change, or I guess I need to share my screen. Is that right, Shannon?
Yes.
Here we go. All right. Are we good? Does that look okay? Great.
Yeah.
Okay. So there's some key questions that I think a lot of us may have that I just want to go over today and answer for you, about what happens when we die. Who makes decisions about my stuff? Where do my assets go? Who makes decisions about my funeral and my burial arrangements? Who pays for those, for the funeral service? Who pays for the burial? And what must I do to ensure that my wishes are honored? Because of course I'll be gone. Or, and we're going to talk about with the POA, I may not have capacity or the ability to communicate my wishes at the time when those are needing to be communicated. So what can we do now today to plan for what may happen down the road? And, I tell this to all my clients, this kind of stuff, it's not, for most people, it's not our favorite topic to think about, right? But I always say, if we take the time to sit down, think about our wishes, and write them in a way such that they're legally effective, we are giving a gift to our family. We're giving a gift to our loved ones, so that they aren't, we're reducing the likelihood that there's going to be conflict or confusion. And so I look at it as a gift that we're giving to our loved ones by thinking about this stuff now. So let's just start with the first one. Who makes decisions about my stuff? So when someone dies, no one has legal authority to make any decisions about where any of their, when I say stuff, I'm talking about our financial assets. So that can be what we call tangible personal property. That's the items that are in our home, things like our clothing, our artwork, our jewelry, our cars. That can be a bank account. That can be a life insurance policy. That can be a house that we own. Who makes decisions about where that goes? Well, no one can do anything unless it's in a trust. No one can do anything when we die with our stuff that we own until they are appointed as a personal representative. How does that work? So when I die, I've named my husband to be my personal representative. He's going to take my death certificate, my will, to the courthouse in Rockville. It's called the Register of Wills. And he's going to say, I want to open up an estate for administration. The court is then going to look at the documents and say, okay, here you go, sir. You are now appointed as personal representative. You have legal authority to go to the bank, legal authority to gather up the stuff, legal authority to XYZ, to administer the estate. That's called the probate process. Before that happens, even if I've named my husband, he doesn't have legal authority until the court tells him that he does, until he's been appointed as personal representative. Where do my assets go? Good question. This is really going to come down to what assets are probate versus non-probate, and we'll get into that later. But that's a really important distinction about who gets what and when and how. Who makes decisions about my funeral and my burial? Well, this is most often put into what's called an advanced healthcare directive. And that's not going to be a part of my presentation today. I understand that there was another presentation on that topic, so I'm not going to waste your time today talking about that. But in general, the Advanced Healthcare Directive, which is a form where we can make decisions about who handles our personal matters if we lose capacity to do so, our healthcare decision making, there is an option to include information and requests and decision-making authority for things like your funeral and your burial. And I have folks who get, sometimes folks will say, I don't really care. I'm going to be gone. I want my mom to make these decisions, but I don't want to make any specific requests. And then I have other folks who say, I want sunflowers and I want these songs to be played in this order. Last week I had a gentleman who wanted a bouncy house at his funeral. So we can get very creative here, but if you have specific requests in mind, you need to put those in writing in the Advanced Healthcare Directive. I recommend doing that in that document rather than your will, because the funeral and the burial, that is going to happen before we really even get into the will. When someone dies, there's an order of steps that occurs, right? And so by the time we even get to sitting down to reviewing the will and getting it to the courthouse, the funeral and the burial have already taken place. So it doesn't make sense to put this decision-making authority in the will. We put it in the Advanced Healthcare Directive. That's why that's a critical component of everyone's entire estate plan, include not just the will, the Advanced Healthcare Directive. Okay, who pays for my funeral and burial? Sometimes folks will have what we call a prepaid or a pre-need burial contract. This requires you to know where you wish to be buried. Some of those are certainly better than others, and I'm not going to get into the technicalities of that, but if you haven't purchased one of those, your estate can pay for the funeral and the burial, but in practice, what that really looks like is a family member or a loved one paying and then getting reimbursed later by the estate, because of course there's a step process to it. What must I do to ensure that my wishes are honored? You need to write them out in a legally valid and enforceable document, naming a personal representative in your will and naming a healthcare agent in your Advanced Healthcare Directive and indicating your wishes in those documents. That's it. Okay, next step. The legal documents, Advanced Healthcare Directive, we're not going to cover that here, but I just wanted to mention that is separate from the POST form and the DNR form. POST is a form called Physician's Order for Life-Sustaining Treatment, and the DNR is a Do Not Resuscitate. Those three forms are supposed to work together to honor your healthcare wishes if there comes a time that you're not able to communicate those wishes on your own. In addition to that, as part of our whole estate planning, or as part of our entire estate plan, we have the financial power of attorney. This is a very critical document. Everyone needs to have one, period. And then the will, and then a revocable trust, if it makes sense. So we can talk about that. So the financial power of attorney, financial POA, this is for incapacity planning. Who do you want to handle your finances if you lose the ability to do so? This form becomes legally ineffective when you die. So it's really important while you're still alive, if you lose the ability to handle your own financial matters, and no one has any legal authority to do so, meaning you haven't completed a financial power of attorney, your loved ones may be required to go to court and pursue a guardianship over you, which we do not want to do. Most people on this call are probably familiar with guardianship, but if not, I'm happy to explain it to you. It's a legal process where it's an option of last resort. No one else is available to handle the finances for this person. They can't handle them on their own. They have finances that need management. They need to pay their bills. They need to apply for benefits. They're unable to do so. No one has authority to do it for them. Well, we got to appoint a guardian. What the guardianship looks like is a judge deciding who is best to serve in that role. And the judge is legally stripping you of your basic civil liberties. Where do I live? Who do I hang out with? What are my expenses? And giving those rights to someone else, your guardian. So we avoid that. No one wants to deal with that. It's good to have in certain situations, but no one really wants to go through a guardianship. Trust me on that. We avoid that with a financial power of attorney. So in Maryland, for our Maryland clients, we have them fill out 2 forms, and I've included the link here for the, if it doesn't work on your end, just Google Maryland Attorney General Power of Attorney. The Attorney General created their own form. We call it the Maryland Statutory Form. The beautiful thing about that form is that by law, banks and financial institutions in Maryland are required to accept it. A few years ago, they were having issues with folks completing a power of attorney. And then the person that they've named taking that to the bank, and then the bank saying, well, we're not going to honor this because it's not our power of attorney. It's not the Bank of America power of attorney, which defeats the purpose of ever doing the power of attorney in the first place. So the legislature passed a law stating that if folks complete the Maryland statutory form, which you'll find at this link, then it's required to be accepted. I say 2 forms because we also have our own form that we draft in-house. We call it the Durable General. That's just a little more broad. It contains things like gifting authority and establishing certain types of trust that may come up, special needs trusts and things like that. So what we're doing is we're authorizing a person, our agent, to step into our shoes, handle our affairs if we're unable to do so on our own. We're not losing any of our rights to handle our own finances. We're just naming someone to help us in that process. They have a fiduciary duty, a legal obligation to use our finances and our assets for our benefit on our behalf. They cannot, so I give them access to my bank account. They can't take those, they don't legally own those funds. They can't take them on a shopping spree for themselves. They have to use them for me. Distinction between immediate versus springing. You have the option to decide whether to make your power of attorney financially or legally effective immediately when you sign the form, or you can make it legally effective upon your physician or someone else evaluating you and determining that you lack capacity. I prefer, it's your choice, but I prefer and I recommend that folks make it effective immediately, because these forms often come into play in crisis emergency situations. I've seen in the past where someone needs to act under the authority of a power of attorney for their loved one who's been in an accident or in the hospital. Something's happened, and the document is not effective until they've been evaluated by a doctor, and that doctor has said, yes, this person lacks capacity. Well, you know, doctors are busy. It can be hard to track them down. So it can take a couple days to get that in place to then make the document, the power of attorney, legally effective. So that's why I like to make it effective immediately. Yeah, so and then it terminates when you pass away. So anyone who's acting under the authority of a power of attorney, if the person dies, they lose authority to do anything else. Got to open up a probate estate for that, which is where the will comes into play. So we're all probably familiar with with the idea of a will. It's where it's a document that we prepare where we advise what is to happen upon our death. So we use the will to direct the distribution of our probate assets when we die. We can decide. So I say heir versus legatee here, just to explain the distinction between those two. An heir is a family member who can inherit from my estate based upon their relation to me. A legatee is someone who I name in my will. That can be the same person, or it can be separate people. So if you wish to leave property to someone who is not an heir, then you have to make them become a legatee by naming them in your will. We also use the will to name a personal representative. Sometimes this is called an executor to administer our estate. And we use the will to name a legal guardian for minor children. If I have two children, if my husband predeceases me and then I die, my will is going to indicate who becomes the legal guardian for purposes of finances and for purposes of personal decision-making for my minor children. And then the court will look to my will when appointing a guardian for my children. We also use the will to designate and protect funds for minor children, any minor. Kids under the age of 18, they cannot legally accept property. So if anyone in your life you would like to leave something for, if there's even a chance that someone down the line could receive an inheritance under your will, you want to make sure that you set that up accordingly in order to avoid a situation where someone receives assets and they're under 18, then the court has to get involved. And essentially the court is monitoring and directing those funds until that person turns 18. This can also come up in a scenario where a parent leaves a life insurance policy for a child and that child hasn't turned 18 yet. Well, if the parent passes away, so the court has to get involved to get a guardianship established, a custodianship established, and the court's going to monitor and control those funds for that child until they're 18, which can be kind of a hassle. Anytime we have to go to court for anything, as some people may know, it's a headache. So we can avoid that by drafting those provisions within our will. And then we can designate and protect funds for loved ones with disabilities. Here I'm referring to folks that may be on means tested benefits. If they were to receive an inheritance, a check written out to them that they deposit in their bank account, that could cause their benefits, cause them to become financially ineligible. So what do we do in that case? We can put those funds into a special needs trust for that individual. So the funds are still meant for them and still going to be used on their behalf and for their benefit, but they're protected as such, and their public benefits are also protected as well. Okay. And then a revocable trust. I just want to mention this because it's often a question that comes up. People think, well, do I need a trust or do I need a will? And when I say revocable trust, what I'm referring to is a trust that we can set up that we can alter it, we can change it, we can get rid of it, we can do whatever, we can put assets into it, we can take assets out of it, we can do whatever we like while we're still alive. When we die, it becomes automatically irrevocable. And in that way, it replaces the will. So it works together with what we call a pour over will, because if we were to die and we have a revocable trust, but we also have, say, a house that didn't end up in the trust upon our death, the will is going to pour over those assets into the trust and say, okay, look to my trust for what to do with my things when I die. People use revocable trusts for all sorts of reasons. The biggest ones are to avoid the probate process, that process that I was explaining where we have to go to court and get appointed as personal representative. We can avoid that with a trust, because if I die and all of my assets are in my trust, or my trust is named as beneficiary on my things like my bank account and my life insurance policy and my retirement account, then all of those assets pool into the trust. I've named someone called a trustee who has automatic legal authority to handle those assets. They distribute those assets per the terms of the trust as I've directed, and they have authority to do that right away without having to go to a court. So that it offers flexibility, and it also offers privacy, because, as I'll explain, the probate process is not private at all. Okay. What happens if you don't have a will? Many folks die all the time without a will. And so each state has laws in place to control what happens if that occurs. These are called intestate laws or intestacy laws. And these are laws that the legislature in Annapolis has decided that this is who is going to get what if this person dies without a will where they've directed who gets what. And that has to do with your surviving family members, and if you die with a spouse, perhaps, or if you die with siblings or with children, multiple children, whatever it may be, you have to go and look up the law to decide what's going to occur with your things. You also have to look up the law, the intestate laws, to decide who has priority to serve as personal representative, who's going to get control to deal with your stuff, to make these decisions. That's within the law. There's a priority statute in place directing who can serve. So if I want my sister to serve as my personal representative, my husband comes along and says, well, hang on, I've got priority in the law. That's true. So then I need to deal with that by directing in my will that my sister is to serve and not my husband. So there's certainly, as you can imagine, this is going to be ripe for disputes among family members, especially family members that share priority as to serve, and family members who may, be fighting over assets. It can get quite messy. Okay, probate versus non-probate assets. So when I'm talking about a will, I'm explaining that the will controls what happens with my probate assets only. What is a probate asset? I'm going to explain it by saying what is a non-probate asset. A non-probate asset is any asset you own jointly with someone else with rights of survivorship. So that could be if I own my house with my husband. When I die, he automatically becomes the sole owner. No matter what my will says, he's the sole owner. That's a non-probate asset. If I own a bank account, a checking account with my sister, when I die, she becomes the sole owner, no matter what my will says. That's another non-probate asset. When I die, I've named my husband as the beneficiary of my life insurance policy and my retirement account. No matter what my will says, when I die, he has to contact those companies, give them the death certificate. They're going to write him a check, regardless of what the will says. It's a non-probate asset. So probate asset is anything else. Probate asset is assets you own just in your name that don't have a beneficiary, a payable on death beneficiary. Okay. Non-probate assets. Payable on death beneficiary designation, as I just explained. Jointly held assets. A note here to caution regarding creditor protection. Oftentimes, I'll see folks that decide to add maybe it's an older person who needs help managing their bank account. So they'll add their adult child to their bank account as an owner. I advise against this because if there's any creditor that gets any sort of judgment against the adult child, that creditor can pursue and collect the funds in that bank account. We know the funds belong to mom, right? But the by law, those funds are belonging to both of the joint owners. And also, when mom dies, the daughter becomes the sole owner of those assets. Those are hers, regardless of what the will says. If there's a joint owner on the account, they become the sole owner. Life insurance policies where you can name a beneficiary or multiple beneficiaries, retirement and investment accounts, and then what we call real property, which is houses and land. Real property held as tenants with rights of survivorship. Married couples often hold property. It's called tenants by the entirety. That's, as I explained, where the surviving owner, when one person dies, the surviving owner becomes the sole owner of the whole property automatically. That's within the terms of the deed. That's not always the case. Sometimes people can hold real property as tenants without rights of survivorship. In that case, then for that person who's died, their 1/2 interest has to go through probate. And then there's a new owner, which can complicate things, but that's how that works. That's controlled by the deed in the land records. That is it. I went through that fairly quickly. Oh, I shouldn't. This is my, as lawyers do, I've got to put a disclaimer up here. A couple additional things that I want to mention. So in general, what everyone should have to make sure that your wishes are honored is the Advanced Healthcare Directive, the financial power of attorney, the will, and then maybe the Revocable Trust. And that's going to get you set up, and that's just generally. There's a couple more if people have specific questions, a couple more documents that we can talk about, but that's generally what you're going to want to have. So once you've done the will, you can decide whether you want to record the original in the county where you live. I think it costs $5 or $10. You can bring the original to the courthouse, the Register of Wills, they will store it there for you. So when you die, the person you've named in your will as your personal representative, they just have to go to the courthouse and there it is. If we die and we lose the original, that can be a big headache. So it's important to make sure you know where your original documents are stored. Oftentimes, attorneys who prepare the documents will offer at no extra cost to store the originals in safekeeping. And then if you ever need them or your loved ones ever need them, it just takes about a day or two for us to get those out to you. Certainly make copies and give copies to the folks that you've named in those documents. The worst thing you can do is go through the hassle of preparing the forms and then putting them away in a secret location and not telling anyone what you've done. Then they're pointless. Do not put them in a safe deposit box either, because those can be a headache to access as well. So once you've prepared the forms and you know they're legally valid, make sure you know where the originals are, and then talk to your loved ones, talk to your friends, your family members about your wishes. Say, I've named you as my agent to help me with my finances if I'm unable to do so. This is where the original document is. Here's a copy if you want it. And then they know that they need to step up if and when they need to. If your wishes change, oftentimes these things do. If your circumstances change, you know, there's a divorce, there's a death, there's a marriage, there's a child born. Those are times when you should think about if you need to update your documents. And then in terms of finding folks who can help you to complete the forms, my understanding is that most estate planning attorneys you want to feel comfortable with who you're working with. So you can ask them, are you willing to talk in a free half-hour consultation, just so you can see if you vibe with them well, and what their rate is. And then you can get a general, and then ask them what the process is. What's the timeline, and do they have intake forms? Are we going to be meeting in person? Are we going to be meeting via Zoom? How does the signing occur? Do I need to go to your office to sign these forms in front of a notary? What's that process? Those are all good questions to ask when looking for an attorney to help you with that. But in terms of the power of attorney, we can all go today and download the form and get that done. It has to be notarized, but I don't think there's any excuse for anyone to not have a power of attorney in Maryland. So that's my speech. That's my hope for you, that you go today, if you don't have one of those documents already in place, to at least do that. Great. Okay, it's 1:40. So if anyone has any questions, let's see. I don't see any questions in the chat. So if anyone has any questions, feel free to just speak up or write in the chat.
I have a question.
Sure.
Hi, it's Nadine.
Wait a second, Nadine. It's Sarah.
Okay, sorry.
Jenica, can we have you take down your screen share so that we can see all the faces again?
Yes.
Thank you.
All right.
And Shannon, if you'll unspotlight, then thanks.
All right.
Okay.
Now remove the spotlight and still.
It's good. You're good.
Okay. Am I good to go? Okay. So I've been thinking about this for a while. That's why I'm so glad that Sarah had this. I think you guys put this together. So I jumped on it. And I'm trying to find out, are there any resources? I know, because getting an attorney can be pretty expensive. And doing a lot of this stuff can get pretty expensive when you're living paycheck to paycheck and you want to put things in place. This can be really expensive. Are there any resources available for people like me who really want to do something like this?
Well, there's the Advanced Healthcare Directive and the statutory.
Oh, I've got
power of
those things in place already. The will part is what I'm looking for now. So
attorney.
is
Are you
there,
a veteran?
my husband is,
There's something called, what's it called? Wills for Heroes.
ooh,
And it's usually put on either by the local bar association or the local law schools. So I would
Okay.
Google that and see if you can find if they're putting on a one-day workshop, Wills for Heroes. I believe that's what it's called.
All right, I appreciate that because I try to go to the colleges whenever they're having like pro bono stuff, and you can never really get this part of it for free. So, or at least
Yeah.
free, or at least at a low cost that's affordable. So thank you so
Yeah.
much for that.
Sure thing. Yes.
Joyce has her hand up.
Yes, hello.
Hi,
I
Joyce.
wanted to find out if you're familiar with the ABLE program and what your thoughts were about that particular program for folks that have children with disabilities.
I am familiar with it, and I've never personally worked with an ABLE account, but I've heard really wonderful things from people who have. And it's a tremendous resource that should be used oftentimes in conjunction with a special needs trust, because the ABLE account has certain asset limits and income. Well, it's essentially like a debit card that the person with disabilities, Francie is looking at me. I can see her face. Do you want to say something? Okay. The ABLE account, I believe that you can name a beneficiary to receive the funds upon death. Oh, I shouldn't say that because I'm not totally sure. There's a really good Maryland resource on ABLE accounts. Maybe I can just send you the link.
The one thing that comes up for us oftentimes about the ABLE accounts is that you're only able to open an ABLE account if your disability was present before age 26.
That's right.
And
Yeah,
so if your disability, if you did not acquire or have a disability until after 26, you can't open an ABLE account. And so that often comes up for our consumers.
Okay. It's marylandable.org.
Sarah, this is Joyce. I thought someone said they up the age to 40.
I believe there's legislation in this session that would increase the age, but it's not in law yet.
All right, got you. That's one of my biggest concerns with my son that has autism, because every time I put someone down to be in charge, I put like 3 people down and they have passed away. So I'm almost back to the drawing board, but yeah, it's kind of hard. It really is.
What do you mean putting people down to be in charge?
Having them in charge of everything, my will, my directives, and, making sure he's taken care of. He's 32 years old now, but.
I see, within your own documents.
Yes, and
Okay.
my girlfriend, just the one I had in charge, she just passed, the last one, she passed away last Monday. So, yeah.
That's
So
really hard.
It is. You think that you got that part of your life taken care of, you don't have to worry about it, but nobody's here forever. So it's
There
hard.
are some local attorneys who I know who are solo practitioners who serve in those capacities. Of course, they take a fee, but because they're solo practitioners, their fee is much lower than a corporate. If you go to Chevy Chase Trust and you name them as trustee of your trust, they're going to take a massive fee. But
Right.
if that's something that you're interested in, feel free to reach out to me and I'm happy to connect you with those. One attorney is in Frederick and one is in Montgomery County, and they're youngish,
Mhm.
and I think they're fantastic. And they serve in situations where someone is not comfortable naming a family member or a loved one, or perhaps they don't have anyone to name, or they don't want to cause conflict by naming a family member. So it's a thought.
Thank you. Thank you so much. I appreciate that. It's not that you don't trust them, it's they don't know your child like you. Nobody knows your child but you. That's
Exactly.
where I feel. I've gotten my son to a point where they say, oh, it's nothing wrong with him. He's high end. That's not the issue, but I'm not going to take up time. Thank you.
Joyce,
Thank
I'll
you,
send you
Joyce.
an email. There's another organization called By Their Side. That's a nonprofit organization that's not lawyers, that does some similar estate work. And the whole purpose was that you were sort of grooming advocates that could do some of what you're talking about when the parents were no longer there to do it. So I'll send you the link in an email.
By their side. That sounds
Appreciate
cool.
that.
I want to learn about that too.
Thank you. I appreciate that.
Francine?
I do have a question, but before I ask it, I want to ask Sarah, is there something that the Centers for Independent Living in Maryland and others are doing to make sure that the law or whatever proposal to raise the able age to 40 does not pass? Is there something that you can do about that? That's a question to you, but I also have a question for Jenica.
It's on our list of legislation that we're tracking, but we've submitted some things written wise and otherwise. Honestly, it's something that the IDD community is so working on so
Oh, good.
hard. We feel like there's other things that we, have to put more time on.
Good, thank you. What a relief. Okay, Jenica, you said that banks and financial institutions have to accept a drawn up financial power of attorney, and that there's a Maryland law that outlines that.
Correct.
How come they keep ignoring that? Bank of America says, this is for a friend of mine, no, you have to do something else. What do we do if the institution will not accept?
Do they
Or-
have it? I would first check to see if your friend has the Maryland statutory form. Banks don't have to accept a power of attorney that is not in that form.
I think it is, yeah. She
Okay.
was living in Maryland when she drew it up.
Okay, and as usually Capital One is the one that gives headaches on this, but
Oh.
so I guess Bank of America is also guilty of it. I'm pulling up the code section now. And I would have your friend present the code section. Let's see. Estates and Trusts, section 17108.
17108.
Wait a second. Sufficiency. Okay, sorry, 17104.
Great.
A person, including a bank, may not require an additional or different form of power of attorney for any authority granted in a statutory form power of attorney. A person that refuses in violation of this section to accept an acknowledged statutory form, so if it's signed correctly, witnessed and notarized, if they refuse to accept it, they are subject to a court order mandating acceptance of the order of the power of attorney and liability for reasonable attorney's fees and costs incurred in filing that suit to get the bank to accept it.
Wow, that's great. That's what I want to hear. Thank
Okay.
you. We're gonna
Did you
go
get the
after it.
code section as Maryland Code Estates and Trusts, section 17104?
Thank you.
Mhm.
Thanks very much.
Any other
Danielle?
questions? What's that?
Hi, my name is Danielle.
Hi there.
I was wondering, what is the difference between a revocable and irrevocable special needs trust?
Good question. So the revocable means that the person who we call the grantor, the person who is setting up the trust, can change it. They can update the terms of the trust, like the beneficiary. They can get rid of it entirely. They can transfer assets into the trust, transfer assets out of the trust. We refer to a revocable trust, sometimes as a revocable living trust, as the substitute for the will. And then it becomes irrevocable when we die. Does that make sense?
So a person who is living can also have an irrevocable trust.
Mhm. There's a whole bunch of different types of irrevocable trusts. For example, there's something called a Medicaid Asset Protection Trust. When I set up the trust, I am planning maybe 5 years or more from now to need to qualify for Medicaid long-term care. Well, the rules are very strict on what assets I can have and still qualify. So I can set up a trust, put my assets into that trust, and it's irrevocable, meaning once my assets are there, I legally lose ownership of those assets. They're gone. Now I've done so, the details of that are sort of beyond this presentation, but I've done so with the plan that the terms of the trust, based upon the terms of the trust, when I need Medicaid down the road, I'm going to qualify. If I put my assets into a revocable trust and I try and go and get Medicaid, they're going to say, no, your assets are countable towards that asset limit. Too bad. If they see this as an irrevocable Medicaid asset protection trust, okay, my assets are protected there. So oftentimes we use those trusts for things like creditor protection. It very much depends upon the circumstances, because as you can imagine, once I'm giving up my legal right to those assets, ownership of those assets, I can't pull them out. That could be a big issue unless I've planned accordingly.
You would need to ask the trustee to use them.
Yes. In general, yes. Correct.
Okay, thank you.
So there's one question in the chat. What percentage of your practice is in elder care compared to special needs?
Good question. Oh, special needs. Not sure what. I'll just say the breakdown of my practice is about 50% estate planning, about 10 or 15% estate administration. When I help folks who've been named as personal representative administer estates for their loved ones, there's rules in place for that. And sometimes folks need legal help to manage all of that. And then the remainder is elder law, which I used to refer to as guardianships and qualifying for Medicaid to pay for long-term care nursing facilities. And then a small component is setting up and administering special needs trusts. That's my practice. Any other questions? Well, if anyone thinks of anything else, don't hesitate to email me or give me a call. You have my contact information and I'm around.
We have one more question. Musa? You're on mute. One last question.
If there is anything to do like money, I don't have nothing, but the few dollars I have here for say, if I'm dying, where is it going to be? Where is it going to be at?
I think I understand the question to be, if I die and I don't have a lot or any assets, what is going to happen? Is that right?
Yeah.
So if someone dies and they don't have anything to leave, which happens all the time, then it may be that there's no need to go through the probate process. There's no need to open up an estate. There's perhaps maybe I just have a bank account and my bank allows me to name a beneficiary that gets those funds when I die, great. Then they get the funds. There's nothing else in my name. No one is going to open an estate, meaning, and sometimes people die with a lot of assets, but they have more creditors. So if I die and I have a Visa bill, a credit card bill of $10,000, Visa can get paid from my estate before anyone else gets any of the money. So if my loved ones never open up an estate for me, Visa's never going to get paid. Sometimes it makes sense to not ever open up the estate. So in that case, of course, a will is not necessary. If we know that there's not going to be any probate assets. It's easier said than done to know that there's going to be no probate assets. So I'm going to recommend we all do one. But certainly if we die without any probate assets, it's not necessary.
If I die like me, $800, that's what I got. How can I how can the money be $800?
I can't follow. I don't know the question. Can you say it in another way?
Did he get disconnected? Looks like he got disconnected. So there's one more question, Cindy. And it's 1:57. Cindy?
I have to unmute myself. First of all, I want to thank Seneca and everybody else for this very, very enlightening. So the question I have is, if I have a bank account and it's upon death to somebody, right? They're just me and upon death, then what do they need to do? Just give a birth certificate, or I mean a death certificate, and then they just get the funds?
Yeah, that's usually how it works. It's
So
dependent upon the bank.
right.
Each bank has their own procedure, but in general, that's how it works. They just get a death certificate. They look up in their records. Okay, Cindy's named so-and-so as beneficiary. We're going to send them the check.
Okay, so then my other question is, if I have a bank account, and let's say I have a couple bank accounts, right? And maybe I have creditors. So if this one account is, upon death goes to so-and-so, and I have creditors, can they come in prior to that and take money?
No,
Or can they come into, is that only if I don't have a will, or or let's say I have a will?
if you've named someone as beneficiary of your bank account, that's not a probate asset. The creditors are not going to access those funds.
Okay. Okay, thank you. And thank you again for the presentation.
Sure, certainly.
It was really wonderful.
Oh, good. I'm happy to hear that. Okay, great. We did it in 1 hour. Thank you so much for having me here. It was a pleasure. I'm happy to speak with anyone afterwards. If they have any other questions, feel free to email or call me.
Thank you so much.
Thanks,